You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. When comparing privacy laws across different domains, one of the clearest distinctions is in scope. U.S. federal statutes are sector-specific, such as HIPAA for healthcare, GLBA for financial services, FERPA for education, and COPPA for children's data. Each applies only to particular industries or types of data. By contrast, state-level laws like California's CPRA, Virginia's CDPA, and Colorado's CPA cover a broad range of businesses that meet thresholds for revenue, number of residents, or data processing volumes. International regimes like the GDPR and the UK Data Protection Act are even broader, applying to nearly any entity handling personal data of covered residents. This comparison shows how federal laws leave many gaps filled by state and international frameworks. Learners should recognize scope as a foundational difference. Narrow sector rules, broad state acts, and sweeping international mandates create overlapping obligations businesses must harmonize. Role definitions further reveal how regimes diverge but also converge on common themes. Federal U.S. statutes tend not to use modern role-based terminology. Instead, they describe covered entities, business associates, or financial institutions. State laws have adopted role definitions that mirror international standards, distinguishing controllers that decide purposes and means from processors that act under their instructions. California adds its own refinements by labeling service providers, contractors, and third parties, each with distinct duties. International frameworks like the GDPR use the controller-processor split as the backbone of accountability, with strict contractual requirements and flow-down obligations for sub-processors. Learners should see role definitions as building blocks for allocating responsibility. Even though terms vary, the principle is consistent. Those who determine data use bear heavier burdens, while those who process must follow strict instructions. Despite differences in structure, most regimes converge on a portfolio of individual rights. Access, correction, deletion, and portability appear in nearly every modern law, though terminology varies. HIPAA guarantees patients rights to their health records. FERPA grants students access to educational files, and state privacy acts give consumers the ability to see, correct, and remove personal information held about them. The GDPR unifies these as core data subject rights, layering portability as a tool for consumer empowerment across services. Even when laws diverge in detail, such as timelines for fulfillment or scope of data covered, the theme is unmistakable. Individuals are no longer passive subjects of data collection, but active participants with actionable rights. For learners, this reflects a philosophical shift. Privacy laws increasingly emphasize personal agency over information flows. Opt-out mechanisms highlight another area of state-level innovation. California grants consumers the right to opt out of both selling and sharing of personal data, explicitly capturing cross-context behavioral advertising. Colorado and Virginia extend opt-outs to targeted advertising and certain profiling that produces legal or significant effects. Federal statutes, however, rarely use opt-out constructs, focusing instead on affirmative duties of covered entities. International frameworks like the GDPR lean toward opt-in consent models, requiring explicit permission for most processing. Learners should appreciate that opt-out and opt-in are two sides of the same coin. Both aim to ensure control, but one presumes participation until refused, while the other presumes exclusion until permission is given. Understanding these differences is vital when designing compliance programs across multiple jurisdictions. Sensitive data handling illustrates how consent thresholds vary globally. U.S. state acts generally require opt-in consent for categories like health data, biometrics, precise location, or information about children and teens. COPPA takes this further by demanding verifiable parental consent for those under 13. International frameworks set even higher bars, requiring explicit consent or narrow legal bases before processing special categories such as racial or ethnic origin, political opinions, or religious beliefs. The practical effect is that sensitive data receives heightened scrutiny everywhere, but the mechanism for permission shifts depending on the regime. Learners should see sensitive data guardrails as both a compliance obligation and an ethical checkpoint. When dealing with data that can reveal intimate details, laws converge on stricter standards to prevent misuse. Purpose limitation and data minimization principles align across federal, state, and international regimes, though expressed in different language. State acts prohibit collecting or processing beyond disclosed purposes, while the GDPR enshrines these principles as foundational requirements. Collect only what is needed and use it only for specified, legitimate ends. Federal laws like HIPAA also enforce purpose specificity by restricting data use to treatment, payment, or healthcare operations unless authorization is obtained. Learners should think of these principles as the privacy equivalent of a diet plan. Only take in what is necessary and avoid excess. Limiting scope not only reduces compliance risks but also lowers the volume of data exposed in breaches, reinforcing both legal and security benefits. Retention rules provide another point of comparison. U.S. state acts require businesses to disclose retention schedules or at least explain criteria used for deletion. International frameworks codify storage limitation, requiring that personal data be kept only as long as necessary for the purposes originally identified. Federal sectoral laws also impose retention and disposal rules, such as HIPAA's requirements for medical records or the Fair Credit Reporting Act's restrictions on consumer reporting data. Learners should note that while language differs, transparency in one system, limitation in another, the effect is similar. Organizations must think critically about how long data remains in their custody and be prepared to justify that decision to regulators or courts. Notice requirements illustrate both shared and divergent practices. Federal laws often require specific notices, such as HIPAA's Notice of Privacy Practices or GLBA's Financial Privacy Disclosures. State acts demand layered privacy policies describing categories of data collected, purposes, recipients, and retention. California goes further, requiring disclosures about financial incentives and explicit recognition of global privacy control signals. International frameworks like the GDPR mandate transparent notices at the point of collection and demand clarity about lawful basis for processing. Learners should see notice as the transparency instrument of privacy law. Whether in a healthcare clinic, on a retail website, or in a mobile app, organizations are expected to communicate in plain language how they use personal data. Security requirements are framed differently but reflect a common expectation. Organizations must protect personal data with appropriate safeguards. State acts often reference reasonable security tied to risk and sensitivity, leaving interpretation flexible but enforceable. HIPAA establishes the security rule, demanding administrative, technical, and physical safeguards for electronic health information. The GDPR requires controllers and processors to implement appropriate technical and organizational measures based on risk. Learners should understand that although terms like reasonable or appropriate may sound vague, regulators interpret them through context size of the organization, nature of data, industry norms, and evolving threat landscapes. Ultimately, security is not optional. It is a baseline duty that binds every regime. Data protection assessments illustrate how proactive governance is becoming a universal expectation. State acts require assessments for high-risk processing activities, like targeted advertising, profiling, or sensitive data use. The GDPR mandates data protection impact assessments in similar scenarios, especially when new technologies or large-scale sensitive data processing are involved. Federal statutes rarely use assessment terminology, but regulators increasingly expect documented evaluations of risk and safeguards. Learners should see assessments as privacy's version of pre-flight checks. Before launching a system, organizations must prove they have thought about risks, alternatives, and mitigations. These documents also become critical accountability artifacts in investigations or audits. Children's protections stand out as another converging theme. COPPA set an early standard in the U.S. requiring verifiable parental consent for data collection from children under 13. State acts extend protections to teens under 16, often restricting targeted advertising or requiring higher privacy defaults. Internationally, the GDPR requires parental consent for children under 16, though member states may lower this to 13. California's age-appropriate design code goes even further, requiring design-based protections like high privacy defaults and limits on manipulative nudges. Learners should recognize that across jurisdictions, youth protections are treated as a priority, reflecting the heightened vulnerabilities and long-term consequences of data misuse for children and adolescents. Automated decision-making governance is emerging as a major point of comparison. Federal laws provide little direct coverage, though agencies like the EEOC and FTC have begun scrutinizing algorithmic bias. State acts like Colorado's CPA and New York City's AEDT law impose testing, documentation, and bias audit requirements. The GDPR explicitly grants individuals the right not to be subject to decisions based solely on automated processing that significantly affects them, unless safeguards like human review and appeal are in place. Learners should see admiral governance as the next frontier in privacy. As algorithms take on larger roles in employment, credit, insurance, and education, laws increasingly require transparency, fairness, and recourse. Vendor contracts are one of the most consistent features across regimes. State acts require contracts between controllers and processors, with clauses addressing instructions, security, and sub-processor approvals. Federal laws like HIPAA mandate business associate agreements, spelling out confidentiality and safeguards. The GDPR demands detailed contracts and imposes liability for failures in the chain. Learners should see contracts as privacy's connective tissue. They ensure obligations flow through ecosystems of vendors and partners, preventing weak links in data protection. Contractual flowdowns and audit rights extend compliance obligations beyond the first-tier relationship, embedding privacy expectations throughout the supply chain. Finally, accountability artifacts unify the comparison across federal, state, and international domains. Metrics on rights request fulfillment, audit reports, board-level presentations, and independent assessments are all evidence regulators look for. The GDPR emphasizes accountability as a principle, requiring organizations to not only comply but also demonstrate compliance. State acts echo this by mandating retention of risk assessments and rights-handling records. Federal regulators similarly expect documentation during investigations. Learners should view accountability artifacts as the proof behind promises. Policies and contracts may look good on paper, but without metrics, audits, and board oversight, organizations cannot show regulators that privacy is more than an aspiration. It is an operational reality. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. International data transfers present a striking contrast between U.S. and global frameworks. Under the GDPR, cross-border flows must be justified by mechanisms like adequacy decisions, standard contractual clauses, or binding corporate rules. These are contractual or regulatory guardrails that ensure equivalent protections travel with the data. By contrast, U.S. state laws tend to rely on disclosure rather than strict transfer bans. Businesses must inform consumers if data is shared outside the country, but are not generally barred from doing so. For learners, this difference shows two philosophies at work. Europe emphasizes continuity of protection regardless of geography, while U.S. state laws prioritize transparency and consumer choice. Multinational organizations must often implement GDPR-level transfer safeguards globally, even when not legally required, because consumers and partners increasingly expect cross-border accountability. Government access and lawful process obligations also intersect across domains. U.S. companies frequently receive subpoenas, national security letters, or warrants compelling disclosure of personal data. State privacy laws generally carve out lawful process exceptions, while the GDPR requires disclosures to foreign governments be assessed against European legal protections, sometimes creating tension. To manage this, organizations issue transparency reports, disclosing the volume and type of government requests they receive. For example, large cloud providers publish biannual reports detailing thousands of requests worldwide. Learners should see this overlap as a reminder that privacy compliance is not only about consumers, but also about responding to governments. Transparency reporting has become a trust-building tool, bridging public accountability with legal obligations. Breach notification standards reveal both shared goals and sharp divergences. U.S. state laws vary from 30 to 60-day limits, often tied to unreasonable delay standards, while HIPAA imposes a 60-day maximum for health data. The GDPR is stricter, requiring notice to supervisory authorities within 72 hours of discovery, unless the breach is unlikely to result in risk to individuals. Content requirements also diverge. Some U.S. states mandate credit monitoring offers for Social Security number breaches, while the GDPR emphasizes describing impacts and mitigation measures. For learners, the lesson is that breach readiness must be calibrated to the toughest standard. If an organization can meet GDPR's 72-hour regulator notice and pair it with state-level consumer letters, it will exceed expectations everywhere. Harmonizing breach processes avoids confusion and builds resilience. Enforcement models differ widely. Federal regulators like the FTC, HHS, or CFPB enforce sectoral laws. State attorneys general lead investigations under state statutes, and international regimes empower independent data protection authorities with sweeping powers. Some states allow private rights of action, though these remain limited compared to Europe, where individuals can lodge complaints directly with supervisory authorities and pursue damages. The mix of public enforcement and private remedies creates overlapping risks for businesses. For learners, the key is to recognize that enforcement posture shapes compliance priorities. In California, consumer lawsuits after breaches are a serious risk. In Europe, administrative fines dominate headlines, and at the federal level, settlements and consent decrees drive reforms. Organizations must anticipate all three models in their compliance planning. Penalty structures also vary. U.S. state laws typically set fines per violation, often $2, $500 to $7, $500, with multipliers for intentional or child-related violations. HIPAA penalties can reach $1.5 million annually per violation category. By contrast, the GDPR allows fines up to 20 million euros or 4% of global annual revenue, whichever is higher. These eye-catching figures have reshaped executive awareness of privacy risk. Learners should understand penalties not just as numbers but as reflections of values. Europe emphasizes deterrence and proportionality, targeting the largest companies with global revenue-based penalties, while U.S. laws emphasize per-consumer remedies. Both approaches highlight that privacy violations carry financial consequences, but the scale and philosophy differ across regimes. Universal opt-out signals represent another point of divergence. California and Colorado require businesses to honor browser-based signals like global privacy control, treating them as valid consumer opt-outs from sale or sharing. Internationally, consent frameworks remain dominant. Organizations must obtain affirmative opt-in consent rather than simply respecting refusal signals. For learners, this highlights the technical challenges of interoperability. A business serving both U.S. and European consumers may need systems that both detect and respect automated signals while also capturing explicit consent for international compliance. Designing these systems requires blending recognition of technical signals with storage of consent records, an example of how law and technology must work together to support privacy at scale. Certain categories of data consistently draw heightened scrutiny across all domains, Biometric identifiers, health information, and precise geolocation are treated as especially sensitive due to their permanence, vulnerability to misuse, and potential to reveal intimate details. State laws often require opt-in consent for these categories, while HIPAA and international frameworks impose additional protections and restrictions. For example, the GDPR classifies health and biometric data as special categories, requiring explicit consent or narrow legal bases. Learners should recognize this alignment as an emerging consensus. While frameworks differ in language, they converge on the idea that some data types are too risky to treat like ordinary information. These categories act as red flags for regulators and demand stronger safeguards in practice. Data broker regulation illustrates an American innovation spreading unevenly. California's Delete Act, Vermont's registry, and Oregon's broker laws require registration, disclosures, and sometimes centralized deletion mechanisms. No comparable system exists in Europe, where broader accountability principles apply instead. Federal laws remain silent on brokers, leaving states to experiment with registry-driven transparency. Learners should see data broker rules as targeted attempts to shine light on invisible actors in the data economy, companies that buy and sell personal data without direct consumer relationships. For multi-state organizations, these laws create new compliance checkpoints. Registration deadlines, annual attestations, and deletion mechanisms must all be integrated into operations alongside broader privacy programs. Profiling and automated decision-making safeguards vary but increasingly intersect. The GDPR restricts solely automated decisions with significant effects, granting individuals rights to explanation and human review. Colorado and Virginia add profiling opt-outs, while California ties automated decision-making governance to rulemaking under its privacy agency. Federal law remains fragmented, relying on sectoral oversight, such as credit scoring under the Fair Credit Reporting Act. For learners, the big picture is that algorithms are under scrutiny everywhere, but protections differ in depth. International regimes demand fairness audits and appeal channels, while U.S. states focus on opt-out rights and transparency. Together, these form a patchwork that organizations must reconcile when deploying artificial intelligence in global or multi-jurisdictional contexts. Cross-border e-discovery highlights another challenging overlap. U.S. litigation often demands broad data production, while European rules restrict transfers unless safeguards are in place. This creates tension when American discovery obligations collide with GDPR transfer rules. To resolve this, companies use protective orders, anonymization, or restricted review platforms to balance obligations. Learners should understand e-discovery as a practical collision point. It forces organizations to reconcile U.S. legal traditions of disclosure with European insistence on privacy. Handling litigation data flows requires careful negotiation, technical controls, and documentation to satisfy both court orders and privacy regulators. To manage these complexities, organizations increasingly adopt harmonization strategies by applying the most protective baseline across jurisdictions. This means using GDPR-level consents, California-style notices, and Colorado's universal opt-out recognition as a global standard. While resource-intensive, this approach simplifies operations and reduces the risk of undercompliance. For example, a multinational might apply a 72-hour breach regulator notice rule worldwide, even where longer timelines exist, ensuring consistency. Learners should see harmonization as a practical strategy. It transforms patchwork obligations into a unified compliance culture, easier to manage and defensible under scrutiny. Template libraries play a vital role in harmonization. Organizations prepare regulator notices, consumer letters, contracts, and FAQ documents that meet the strictest requirements, then tailor them downward as needed. For example, GDPR-compliant privacy notices can be adapted for U.S. states by adding opt-out disclosures. This reduces drafting time during crises and ensures consistency across channels. Learners should recognize template libraries as a cornerstone of operational efficiency. They prevent last-minute scrambling and keep messages aligned even under pressure. Evidence repositories reinforce this approach by storing audit packs, regulator-ready documentation, and rights-handling logs. These repositories provide a single source of truth during investigations or audits. For instance, when regulators ask for proof of timely breach notice, organizations can produce time-stamped records of detection, decision, and dispatch. Learners should see evidence repositories as the accountability engine. They transform compliance from a matter of trust into a matter of proof, demonstrating that obligations were met not just in theory, but in verifiable practice. Finally, global operating models synthesize policy, technology, and vendor controls. They align corporate policies with international principles, configure technical systems to detect and honor rights signals, and bind vendors through contracts and audits. For example, a unified operating model might integrate data retention schedules, consent management platforms, and incident response playbooks into a single governance framework. Learners should understand that harmonization is not only about legal alignment but also operational design. By weaving together policies, technology, and partnerships, organizations create resilient systems that satisfy diverse regimes and build trust with consumers worldwide. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.